Good afternoon, colleagues, distinguished guests, members of the African Labour Law Society, and friends from the labour law community. It is my pleasure to welcome you today to our webinar on the right to strike under International Labour Law Organization Convention number 87, the International Court of Justice's advisory opinion of 21 May 2026. This webinar comes at a particularly important moment in the development of international labour law, following years of debate and uncertainty regarding the interpretation of Convention number 87 and whether it protects the right to strike. The International Court of Justice has now provided guidance on a question that has occupied governments, employers, trade unions, practitioners, and academics around the world for more than a decade. We are very privileged to have with us a distinguished panel to help us unpack the court's reasoning, consider the implications of the advisory opinion, and reflect on what it means for the future of labor law and industrial relations globally. Our moderator is Professor Evans Kalula, an Emeritus Professor of Law at the University of Cape Town and Chairperson of the ILO Committee on Freedom of Association, the first African to hold that position. Professor Kalula has made an extraordinary contribution to labor law scholarship and practices both in South Africa and internationally. We are delighted to also welcome Professor Jeffrey Voigt, Managing Director of the International Lawyers Assisting Workers Network, a member of the ILO governing body, and a member of the ILO Committee on Freedom of Association. He is also the co-author of The Right to Strike in International Law and has been at the forefront of many of the international debates surrounding this issue. We are equally honored to welcome Professor Halton Cheadle, Emeritus Professor of Law at the University of Cape Town, and one of the principal architects of South Africa's modern labor law framework, including the Labour Relations Act and other key labor legislation enacted during South Africa's democratic transition. Joining them are Mr. Alex du Plessis and Mr. Jeffrey Alsop of the employment team at Pinsent Masons. They advise South African and multinational employers across Southern Africa and bring valuable practical insights into the implications of international labor law standards for employers and practitioners alike. And on behalf of the African Labour Law Society, I would like to extend our sincere appreciation to all our panelists for taking the time to share their expertise with us today. The format of this session will be a panel discussion, followed by an opportunity for questions and comments. I encourage you to submit your questions through the Q&A function as the discussion progresses. Without further delay, it is my pleasure to hand over to Professor Evans Kalula to open our discussion. Professor Kalula, the floor is all yours.
What?
You're on mute, Prof.
Lo siento, je m'excuse. I'm sorry, I'm BBC, born before computers and reconstructed. Thank you very much, Vice President Keshni Naita. Sounds great, doesn't it? For those introductions, you really appreciate it. Good afternoon, fellow participants, fellow members of the society. I thought I should start by thanking and congratulating my speeches. I've got a speech impediment. I'm sorry about that. To salute, that's what I meant to say, the society for this yet another kind of enlightening webinar, which the society has put on from time to time. And I should commend not only the executive, the president, and the executive, but also the gaffers behind it, meaning Claire and Connor Fincham, who always, they are sort of their remarkable efforts in linking us up is just extraordinary. And just to ask you, those of you who are in better climates, to spare a thought for us down here in the uh, fairest Cape. It's not as fair anymore. It's damp and chilly, but sort of we are trying to do our best to keep warm. So welcome to you all. Before I sort of I begin facilitating, because that's my role, I would like to recognize a number. I mean, for starters, it's amazing. I think we have got over 50, 55 participants, and I congratulate you all for making time to participate in this webinar. I would like in particular to recognize a few uh, luminaries, if I may put it that way, who I know are in the audience, starting with uh, a member of the Committee on Freedom of Association, who is the spokesperson of the government group, and that is Mr. Sipon Devere. I suspect another member, Kaiser Muyane, might also be in attendance. I know that the judge president of the labor courts in South Africa had indicated his intention to join. I'm not sure. I do hope is with us. We also have in our midst Judge Rachel Squese, a stalwart and veteran of labor law. She is a member of the Court of Appeal bench in Malawi and also a member of the UN Tribunal, Staff Tribunal. I think she's in the audience. And we also have in our midst, South Africa has got this, I suppose, this gift of sending the world very distinguished people who go and serve there and then sort of quietly come back. And one of those has been at the ILO. And for those of you who are familiar with social dialogue and collective bargaining, she's the mind behind most of the ILO publications on that subject. And is Susan Hayter. She's at home now, back to Cape Town to have a break. And I know she's with us. I would like to welcome her as well. But let me, before last but not least, that's what I'm trying to say. Welcome, I suspect, the founding father of the society, African Labor Law Society, Professor Stefan van Eck, is with us. I need not say anything about the Stefan. Stefan, of course, is, as I said, the founding father of this society. And as at the vision, which I shared at the creation, if you like, of uh, uh, spreading the word, so to speak, about labor law, and then particularly our emerging kind of practitioners and scholars. So, Stephanie, if you are with us, I welcome you. I suspect also a previous president of the society, Pami Bam, might be with us. I don't know whether the president is with us, President Tafa, whether he's with us as well. So it's really an honor for me to be able to play this role. I mean, I think the questionnaire was very too generous about introduction. I'm basically a cheerleader. I don't have any I don't have any claims. Like Clint Eastwood, of all people, once said, "I know my limitation. A man must know his limitation." But it's an honor to be part of this, and I know the panelists have been introduced, but I can't resist sort of calling Hatton Chido to book for his sins. We are all sinners, but Hatton Chido is more of a sinner than most when it comes to labor law. I mean, it was mentioned that he created, in a sense, as convener of the Labor Relations Committee that drafted the Labor Law Relations Act. He's a creator, and ever since he has been trying to, uh, to deny any faults that have been found with this legislation. But Chido did not stop there. He went and sort of helped with the new labor law in Tanzania, Nigeria, and the Labor Relations Act for all its force and benefits as is now a model in many African countries. And as if that were not enough, he served as a member of the committee, the ILO Committee of Experts for 3 terms. And in fact, he's an interested uh, person in a sense, because he was part of the group that put together the case for the ILO before the ICJ. So there you are, Professor Chido. I call you the great man because, like my father, my late father, and this was long time ago when you were an angry young man, you actually stood before factories, in front of factories recruiting. So you are not only sort of a practitioner or academic. You have been, what is on the ground with locking people, working people. So I salute you. I must admit, I'm a fan. So that's a critical fan. Because on a good day, as I always tell you, you have got no equals. But not all the days, as we all of us, are the best days. So I thought I should say that. And my colleague, uh, Jeff Voigt, is a star. I mean, the current Committee on Freedom of Association, which for my sins, I'm chairperson of, is a remarkable committee in terms of the strength of the representatives there. We have 6 representatives from government, 6 from workers, and 6 from employers. And it's amazing. Jeff, of course, is sort of a leading representative for the workers' side. As he was introduced, is a fellow traveler when it comes to workers' rights for a long time, and he still has a long time to go. He's a young man, so he's sort of the best is still to come if the world allows him, and the world is changing, and as he knows. So I thought I should say that as a preliminary remarks, and allow me, uh, fellow participants, now to come to how we are going to proceed with this webinar. As Keshini said, Jeff will lead us with a presentation, which you speak to for 10 minutes. And please, as Keshini mentioned, the whole presentation, and in fact, something else, because before this, Jeff, I think, wrote a very enlightening piece. I think those should be put on YouTube for people to follow. And I would invite any participants who may have something to say to be sent to Corner, to be put on YouTube for all of us to say. And last but not least, I tell you, I'm sort of, it's a combination of senior moments and the addiction to prescribed drugs. I forgot to mention Dr. Atalia Mlukome. Atalia is a new member, in fact, who succeeded rather, Professor Chido as a member of the ILO Committee of Experts. I know she mentioned that she would attend. I think she's here just to welcome her. So this is an exciting full house. And then I will now call upon Jeff to present for 10 minutes, after which Professor Chido and Alex and Jeffrey will also make their inputs, and then after that, I think they can respond to the discussions. Before that, I I would like to mention that my views, I've got no views on this question. I'm an independent chairperson, so I've got no views. Jeff obviously has got views, and his views, of course, his individual views as a worker representative. They do not represent the ILO, because the governing body still has to consider this opinion. The ICJ opinion is simply that. It's an advisory opinion that the governing body of the ILO is going to consider in November at this next sitting. And for that reason, we did not even discuss it in our June session of the Committee on Freedom of Association. So, Jeff, please, can you go ahead? And thank you.
Thank you, Professor Kulula. Yes, I'm going to briskly go through a set of slides which summarize some of the key points of the decision. And yes, I'm speaking as a representative of the ILO network, and I was an advisor to the International Trade Union Confederation throughout the process in their advocacy before the court in this case. So again, I may proceed through some of these briskly to keep to 10 minutes. But the question before the court was simply whether the right to strike of workers and their organizations is protected by Convention 87 of the International Labor Organization. And on that question, the answer is yes. So I'm going to really go to the kind of the methods by which the court came to that conclusion. Of course, and treaty interpretation, the International Court of Justice applies the Vienna Convention on the Law of Treaties, which, for this purpose, is principles that have been accepted in customary international law. And so it looked to the ordinary meaning of the text of the convention in light of its context, object, and purpose, and looking particularly at Articles 3 of the convention read together with Articles 2 and 10. And I'll get to that in more detail in the following slides. Other relevant rules of international law. And here in particular was interesting looking at the two international covenants on economic, social, and cultural rights and the covenant on civil and political rights as forming an additional relevant rule of international law to confirm the interpretation under Article 31, as well as supplemental means of interpretation. And here we take a look at the output, the conclusions, observations, conclusions, recommendations of the ILO supervisory system, whether the Committee of Experts or the Committee on Freedom of Association. And in particular, what they didn't find in the supplemental materials is that the preparatory materials, the travaux préparatoires, did not affirmatively exclude, they found no exclusion of the right to strike in the negotiating history. as had been one of the primary arguments put forward by the employers group. So when we talk to the issue of ordinary meeting, the court looked to the kind of four corners of the convention and looked to Article 2, which noted a right to form and join organizations. 3, and this is really the core, the right of those organizations to organize their activities and programs without interference from public authorities. Also looking at Article 10, which goes to the purpose of such organizations and the purpose being furthering and defending workers' and employers' interests. Right? And found that strike action is capable of falling within the ordinary meaning of the term activities. And the convention has two exclusions, excluding the right of giving governments flexibility to exclude police and the military from the right to freedom of association. So it was clear that the drafters knew how to exclude things from the scope of the convention. Those were the only two things excluded. And so, again, looking at the text, activities and programs, and looking at what is the object and purpose of this convention. Again, looking at the preamble, which tied it into the Constitution of the ILO and the questions of social justice, it became clear that if this convention were to have any legible meaning, that these activities for furthering the interests, rights, and interests of workers' organizations had to include the mechanisms by which workers can exert pressure in not only in the collective bargaining process, but in the collective bargaining process. And importantly found that strike action is one of the main activities engaged in and tools used by workers and their organizations to promote their interests and improve conditions of labor, thereby ensuring the effective exercise of the freedom of association protected under Convention 87. That's a quote from the court. So, so they found no problem looking at the text, even though it does not use the word strike, that the term activities and programs are capacious enough to include the concept of strike action. Another interesting development in the case, again, is this cross-instrumental reading with the two human rights covenants. In Article 8 of the Covenant on Economic, Social, and Cultural Rights, you have the express right to strike articulated and cross-referenced back with Convention 87. Similarly, in the ICCPR, Article 22, freedom of association is protected, again, also referenced back with the Convention 87. And so it was clear that there was that these Convention 87 and these two articles in the covenant were meant to be kind of interlocking parts of a whole. And that given the very significant overlap between those states who have ratified Convention 87 and had ratified the two covenants, that the court decided that the two covenants are also provide an important source and support for the fact that the right to strike is protected in Convention 87, and the supervisory systems of both the ESCR and the ICCPR had also interpreted the right to strike as protected by those respective articles. Yeah. So also important in the decision, and this is coming in through Article 32 of the Vienna Convention is that there is, and the court spent a good amount of time looking at again, the output of the supervisory system, and then referring to a previous decision, the Diallo decision, determined that the supervisory system's output was accorded great weight, uh, making the analogy of the ILO, the Committee on Freedom of Association, the Committee of Experts, to the UN Human Rights Committee, which was the body that was given deference in the Diallo decision. And even though they are not treaty bodies in the conventional kind, they perform a functionally equivalent role. And I think there's argument to why they should be afforded even greater weight than in the Diallo decision, but wasn't necessary. Um, so the court notes that the Committee of Experts has read Article 3 to protect the right to strike since 1959. The CFA has also done so for nearly as long. It's interpreted the right to strike as a general principle early on, but also specifically tied to Convention 87. And I think this is important, not be only for this particular case, but this endorsement about the value of the supervisory system, I think, is helpful in giving a boost to the supervisory system as a whole and reaffirming its competence in interpreting the conventions before it. Also, in Article 32, the court looked to regional human rights courts and commissions, looking specifically at the fact that the Inter-American and European human rights courts had also determined, again with reference to Convention 87, that the right to strike had been protected, either in Article 11 of the European Charter or the European Convention, or in the Inter-American Framework in the American Convention and Protocol, and also noting that the African and Arab human rights frameworks in their instruments had also protected the right to strike. So again, one of the main employers' arguments from 2012 through to the dispute before the court was that the drafters of Convention 87 affirmatively decided to exclude the right to strike from the scope of the convention, and the silence of the final text of the word strike is dispositive of that exclusion. The court found that the drafting history was inconclusive at best, and to the extent that the right to strike was debated, it was debated largely in the context as to whether public officials enjoy the right to strike and not about the right to strike in general. So the silence of the final text does not sustain an affirmative exclusion. And again, the text isn't really silent in that it provides that activities and programs for the defense of the interests of workers' organizations is protected, right? So just very quickly, there was an interesting concurring declaration by Judge Sarah Cleveland from the United States, arguing that in addition to the decision of the majority opinion of the court, that the right to strike had achieved the principle of customary international law, which was an argument made by the workers group and picked up here by Judge Cleveland. There were 4 dissents, which I won't have time to really get into here, but happy to take it up in any questions. And I think just to wrap up, as time is running short, the decision before the court was, does the convention protect Convention 87? Does Convention 87 protect the right to strike? It was not asked, specifically was not asked what the scope of that right should be, because in our view, that is the role of the ILO supervisory system, and it was not the role of the ICJ to expound on every potential limitation on the right to strike and review every decision that the ILO supervisory system had ever made. That it was sufficient that they decide on the principle that the right to strike is protected in Convention 87, and that the great weight deference standard provided to the ILO supervisory system is sufficient. Of course, this is going to raise some issues within the ILO supervisory system over the scope, and you can see here these are a number of areas that have where there's been debate over the years as to solidarity action, protest strikes, and political strikes. What constitutes an essential service? What are the appropriate procedural guarantees, and so forth. But I think this is something that will be, carried forth in the relevant supervisory bodies. Finally, I think it is our view and the view of the office that under the ILO Constitution, that the court alone gives the convention's authoritative interpretation, and the office has long treated such an opinion as binding on the organization and its supervisory system. That obviously will be a point of discussion when we get to the governing body in November. So a very important chapter in this debate is closed, but of course the work will continue with the work in the Committee of Experts and the Committee on Freedom of Association. So I know I went through this very rapidly. I had only 10 minutes, but thank you very much. And I'll stop the presentation there and turn it over to my colleagues. Thank you.
Thank you, Jeff. Evans, would you like to say something, or should we go straight into Halton's presentation? I think carry on, Halton, if you care to do that. Thank you.
Hi, welcome everybody, and thank you, Vance, for for all the very kind, rather than necessarily truthful things you've said. But Jeff, I think that the overall presentation allows us to concentrate on a few issues, and I think I want to concentrate first of all with the impact it's going to have on the Committee of Experts and the supervisory machinery, both the CFA and the CACR. I joined the Committee of Experts in 2003, and when people talk about that this is a dispute that's a decade old, I really can assure you that this was under pressure when I first joined in 2003. But most importantly, what was under pressure was that the employers were arguing that the Committee of Experts had no interpretive authority at all. And that, I mean, it's if you think about it, it's quite ridiculous, because how could you ever perform a supervisory function to see whether or not a member state that has ratified a convention complies with the convention without interpreting the convention in the first place?
Let me use this.
And I might tell you that I think at some stage in 2005, 2006, it was a lawyer, a British lawyer, attorney that represented business. So the decision in the judgment, and I think it's really important just to look at how what it says, and it finds first of all that supervisory bodies, like the Human Rights Commission, their pronouncements provide an important supplementary means of interpretation under Article 32. And it says it carefully examined the pronouncements of the supervisory bodies that monitor the application of Convention 87 and found that those bodies had progressively converged in recognizing the right to strike as protected under that convention. Now, let me just make the point that one of the employers' arguments was, that when you look at the early days of both the Committee on Freedom of Association or the Committee of Experts, that there was just the odd reference to the right to strike, and that the committee has, on its own, just developed a huge jurisprudence in relation to the right to strike. Well, the language of the convention is general. It's not vague, it's general. It talks about activities, and those activities must comply with the law of the land. But the law of the land can't extinguish the right. That's all contained in Convention 87. And really, our committees, certainly the Committee on Freedom of Association, works on a case-by-case basis. And the Committee of Experts receives reports on legislation, in particular, from periodic reports from member states that have ratified the convention. And it then reviews the law and, on a case-by-case basis, starts developing a jurisprudence. These two committees operate like any common law court does. It develops the interpretation under the convention. So the really important implication is not just in relation to Convention 87, but the fact that the highest court in the world regards the decisions of the supervisory committees as authoritative is really very, very important as a bolster for two supervisory bodies that have been under constant pressure by the employers, not only in relation to the right to strike. Then the second thing I'd like to do is really to look at the scope or content of the right, and what the court says that it made its decision, but, and I quote, does not entail any determination on the precise content, scope, or conditions of the right to strike, and which then I think leaves open a number of challenges, both existing or old and new. And as Jeff has pointed out in his slide, one of the issues that the employers constantly, and states and governments constantly raise, is the committee's restrictive interpretation of essential services. And that is, and I think, given, and I want to expand a bit on it, if we look at digital economies and modern supply chains, the concept of essential services, the committee is really, both committees are going to have to rethink their interpretation of essential services. And the second pushback, both government and employers, have been the permissive interpretation on the part of the committees, to include secondary and solidarity strikes, socioeconomic and protest strikes, and picketing. All of which, personally, I think need to be developed and to include, because of the impact that these have on third parties, that some kind of proportionality ought to be included in its interpretation of these forms of action in the future. And I think if one looks at the South African Labour Relations Act, it attempts to include a proportionality test to the lawfulness or the protected nature of secondary and socioeconomic strikes. The new issues, I think, really entail the problem of the digital economy. It blurs the employment status of platform and gig workers. There's an attempt in South Africa to classify these employees for collective bargaining rights, including the right to strike. But many African jurisdictions remove them from the statutory scope of strike protections by excluding them from the definition of employees. You know, there's, again, in dealing with the digital economy, there's algorithmic control, which Jeff points out, which allows employers no longer need to hire replacement workers. They just deactivate, suspend accounts, and effectively achieving the same disciplining effect of a lockout. Then I think, there are new types of action that employers engage in, like mass log-offs, app boycotts, that don't fit neatly into a legal definition of strike. All of which, in my view, the two committees are going to have to address. And I think one, as far as African labor law is concerned, we should really be considering these implications in our legislation. And then, of course, there's this supply chain structure effects. In a buyer-driven global value chain, the entity with real economic power, all right, that's the brand, is not the direct employer. The direct employer is merely the supplier, and has limited capacity because it's bound by the contract to increase or improve wages. So, I mean, that means, in a sense, that we have to reconsider both the current restrictions on secondary and sympathy action, but also to make it more targeted. So, in other words, the traditional way is to look at some connection. I think that one's probably going to have to be is to allow a secondary, and I don't think it's secondary action anymore. It's direct action against the lead firm. So I think all of that requires doctrinal changes, both in the two committees, and I think as labor lawyers in Africa to look at our legislation. I want to make a final word on whether or not this is binding. I quite understand, and I think it's quite correct for the chair of the CFA not to be all CFA to making any decision on this before the governing body does. But I think Article 37 is clear. It doesn't say refer a question or a dispute concerning the interpretation of a convention for advice. It says for decision. And in section 37(2), which provides for the establishment of a tribunal, so the governing body can, in place of the ICJ, establish a tribunal to authoritatively interpretive or finally interpret these interpretation disputes. But it can only do so if it can do so, but it is bound by any prior decision of the International Court of Justice. Section 37 read as a whole, it is not an advisory opinion. I think it's generally, as far as the doctrine is concerned, it's an advisory opinion unless the actual treaty itself provides for it having final decision-making power. And that, I believe, Article 37 does. And thank you for the opportunity to make these comments.
Thank you very much, Professor Chido. I'm sorry I was something went wrong here. Just confirmed my suspicion about technology. I'm a technophobe. I'm back now just to thank you again, Jeff and Hatton, for your contribution. I think we'll move on to Alex now. Okay. Are you there, please?
Yes,
Alex?
Prof, I'm here.
Thank you.
Thanks, Prof, and good afternoon to everyone and the listeners. What myself and my colleague Jeffrey will try to do is to translate much of what's been discussed into what might be most relevant, or what labor law practitioners in South Africa and throughout Africa might be thinking about off the back of the advisory opinion. I'm not going to be able to add much to what my two colleagues who have gone before me have said with regard to the ILO mechanism and the implications of the advisory opinion. With regard to the ILO and governments, they're in a much better position to do that than I am. But just very briefly from my side as a labor law practitioner, I guess the first point, which has already been made, is that what the advisory opinion does is it recognizes, confirms the right without actually regulating it. And that's been ventilated at some length already. And no doubt what we will see going forward are the various stakeholders engaging in just how that right should come to be regulated. With regard to the convention, in the first instance, the convention would primarily be binding or enforceable against states, but there are certain mechanisms where the convention and the other of the ILO conventions might be enforceable against private employers, large organizations, government employers, and so on and so forth. And those, broadly speaking, would fall into three categories. The first one would be contractual obligations, particularly in the sphere of developmental financing, where one of the large institutional lenders may require that the ultimate borrower of the money commits to ensuring that their workplace adheres to certain of the ILO conventions or standards. And what the impact of that would be now is that the right to strike would now be read into the freedom of association. The second instance might, as Professor Cheadle has already referenced, might be in large organizations' supply chain policies and things like that, where they may make commitments that throughout their supply chain, they will undertake some forms of audits and that sort of thing to ensure that everyone involved, that all the suppliers within their chain throughout the world ensure that their workplaces adhere to the ILO standards. That, again, would be an instance where the convention and now what's been confirmed in the advisory opinion would be applicable against effectively what would be private companies. The third instance where one might find applicability would be where organizations or entities or governments make commitments to particular human rights frameworks, such as the UN Guiding Principles on Business and Human Rights. And I'm sure parties involved there would probably argue that under certain of those frameworks now, the right to strike would need to be respected. So while the ILO and the advisory opinion has perhaps in the first instance is most relevant to states or to the ILO mechanism, there are certain areas where what would effectively be private employers are still or still should be paying attention. The second point that I would like to make very briefly, and it's what Jeffrey very neatly referred to, I think, as the cross-instrumental reading, is that what the ILO, what the advisory opinion does is it certainly draws an overlap between the freedom of association and fundamental human rights. And I've got no doubt that into the future that may be debated between the various stakeholders. But what I think would be noticeable now is that, bearing in mind what the advisory opinion, both under Article 31 and under Article 32, when it considers the regional instruments, when it considers those fundamental or human rights instruments, where now parties are going to argue that that fundamental rights background is engaged, that will arguably affect the quality of justification needed for measures that may restrict either the right to strike or the freedom of association. I think that will be something that practitioners are going to look out for. The third point that I would want to make is that, just from a practitioner's point of view, or just perhaps for me as a South African employment lawyer, it's always an attractive argument to link the right to strike to collective bargaining. But in the advisory opinion, the right to strike is founded within the provisions concerning the freedom of association. And what that may mean, well, what it means is that the right to strike is not, well, would not automatically or necessarily be made exclusively with terms and conditions of employment under Convention 98. So perhaps there's a broader discussion to be had in that regard. So what it does is it doesn't automatically confine the right to strike to the language of negotiating terms and conditions of employment under Convention 98. The second last point that I would like to make is that, obviously, I think what many employers might be looking at now is that by a parity of reasoning, perhaps it's likely that the right to lockout might equally be, if it were put to the ICJ, might equally be recognized. Professor Cheadle will be able to correct me if I'm wrong on this, but I understand it was a submission of South Africa that should, in effect, perhaps already be the case, considering what the supervisory bodies have said. But perhaps many employers might adopt the position that it should just be taken now for granted that the right to lock out should have the same protection as the right to strike under Convention 87. I'll probably leave that debate to those who better positioned than I am to engage on it. The last point that I would like to make is just to is effectively to mirror what my colleagues have already said about what the ICJ said about the under Article 31 and about under Article 32 about affording a great weight to the ILO supervisory body's pronouncements on the convention. And I think what that will, certainly what it might mean for practitioners who ordinarily won't engage in looking to interpret ILO conventions is that, for example, the latest convention on platform workers and the gig economy, now I'm sure, similar to myself, many practitioners will be looking at how the ILO supervisory bodies are going to interpret those conventions going forward, where they might apply to areas of employment law that are not already legislated in South Africa and in Africa. And on that note, subject to any questions, I'll hand over to my colleague.
Thank you. Jeffrey, please go ahead. Thank you.
Thank you. Thanks, Evans. I think I'll be very brief. I don't think there's much that I can really contribute or add aside from what everyone else has said. I do think that, I suppose one of the things that I would say is part of the questions that people ask, at least ask me as a lawyer in South Africa and in countries throughout Southern Africa, is, well, what effect, if I'm a company and I operate in these countries, what effect is this decision going to have on me? And I know that there is at least a contentious issue about the status of the opinion, whether it's binding and whatever that may be. But at least in a country like South Africa and through lots of Southern Africa, there is, at least in principle, a recognition that there is a right to strike. The issue often comes about is, well, what is the content of that? And I think that one of the biggest things that the world of work has changed dramatically, at least in the last 20 odd years, where the traditional sort of model you have of a very clearly defined union on the one side and a company on the other has become increasingly blurred. And at least in South Africa, we have a proposed amendment. I know Professor Shield referred to it, proposed amendments to the Labour Relations Act, a new so-called Schedule 11, which is going to sort of expand the way that people who would not ordinarily fall within the scope of an employee for purposes of collective bargaining would now. And that, I think, is going to be one of the big issues that is going to confront us, at least in South Africa, but also across the world. Similarly, as at least when I was a student, when I first came across this controversy about the right to strike, the part of the issue that seemed to come up was, at least from one of the bodies on the UN, or the employer representatives, was that there was a principled dispute about whether the Committee of Experts or Committees on Freedom of Association have the power to give interpretations of these conventions, and the weight to which that should have. So as much as it was about the right to strike, that dispute, at least to some extent, has been resolved by this ICJ opinion, which I think is quite an important development, where now we're going forward, we're going to have further, when we have things like domestic workers conventions, issues around AI, and the ILO and the Committee of Freedom Committees on Experts will give interpretations of those conventions. That will then be seen, at least to applying this interpretation as the ICJ has put it, is that those views cannot just be sort of viewed as soft recommendations that can be put by the side. They need to be given weight. And if a state is going to give a view that is different, or a body that's going to give an interpretation which differs from that, it would seem then that, at least from a practical perspective, the need to explain why there would be a different view would rest on the state. But that would be quite a complex thing for the future. Again, I think maybe just to close on it is one of the other issues is the issues of value chains. I think that is something that Professor Cheadle raised, and that is also something that is I think that's where the increasing pressure is going to come in the coming years, about how are people going to exercise collective bargaining on the employer side or the employee side, where the sort of the traditional lines are not as clear as they used to be. Yeah, so that I don't think I can really go much more into what other people have added. I think that those would just be my sort of high level 2 cents on the decision.
And thank you very much. Those high levels, they are very meaningful kind of comments. And so, friends, Claire, the gaffer,
Yes.
Connor, what's the state of affairs in terms of the questions now? Do we have any? We
Yes,
don't
thank
have
you.
any
Thank you, everybody.
voice messages. There's no.
No.
Is
So
there a
I'll read
facility
out the
voice?
questions, Prof. I'll read out the question and then the panelists can either just answer or you could direct the question. I'm going to start with the ones on the question and answer platform. From Felix, what are the views of the esteemed panelists on the protection of the right to strike and the exercise of such right against termination based on operational requirements arising from the strike action? What protections are there to ensure that such termination would be in good faith?
I think that question is best put to the practitioners as well as Professor Chido. I mean the U.S. jurisdiction, as far as I know, Jeff, must be too far-fetched in terms of the African experience. So, Alex and Jeffrey, would you want to have a crack at that? And then, of course, Professor Chido come in.
Yeah, I mean, I'll give it a crack. So I think that the answer to that is the rights of undocumented person. Sorry, I think we were talking about the
I think that's
operational
the next question.
Yes.
The first,
So at least I can speak to South Africa. In South Africa, if you have a so-called large-scale retrenchment, you can opt to normally with a union, you can opt to go on a strike to oppose or to sort of pressurize an employer to either call off retrenchments or to reduce the retrenchments, the number of people that would be retrenched. And I think the simple answer to that is that should you be dismissed for exercising that right, your dismissal is automatically unfair. So the law does give you quite a big protection against that. I think that part of the difficulty that arises in practice is if there is a dismissal of that nature, the union would say, well, or the people who are on the receiving end of the dismissal would say, I've been dismissed for embarking on a protected strike and my dismissal is automatically unfair. And then the response of employer would be that, well, no, you were dismissed. The reason for your dismissal was because of operational requirements. So I think the short answer is that you are fully protected in those circumstances, but practically it becomes quite a tricky question about trying to determine what the reason for your dismissal was. Of course, there are clear-cut cases where people are dismissed straight for exercising their rights. But in practice, the sort of the determining whether one falls and where the other, that can be a bit more difficult to figure out.
Thank you, Jeffrey. Alex, do you want to weigh in as well? Please.
There's not much more I'd be able to add there to Jeffrey's answer. So nothing further to contribute on my side on that.
Okay, thanks, Alex. Professor Chido, the last word on this, please. Are you there, Houghton?
Yes, no, I might not be all there, but I am here. Look, very simply, I can't quite remember whether or not the committee of experts has ever had to deal with this situation, but under South African law, with the right to strike, operational requirements, if that becomes it's can be a justified dismissal, and I would assume that although South Africa hasn't signed the Convention on the Termination of Employment, that those principles would be applied by the two committees in dealing with a case like this, where under that convention, the dismissal convention, operational requirements is a justifiable reason for termination. But it always depends on the facts as to whether or not, and strikes can have the effect of reducing market share, which might then require a reduction in the workforce. But under South African law, it would be justifiable if factually proven, and I would assume that the committees would interpret such a matter in a similar manner.
And talking of domestic jurisdiction, I think the questioner, Felix de Setedi, I think, who is from Botswana. I don't know whether the Dr. Atalia is with us. Can't. What the position, Felix, I think you know in terms of what the scope of the labor law in Botswana, in terms of whether it is identical or similar to the South African situation or not to mention other jurisdictions as well who might have different kind of approaches. But thank you very much for that. Claire, next question, please.
From Tabiso in Lesotho, what are the rights of undocumented person who is employed in a country and is dismissed on the basis of immigration laws, but has a valid contract of employment with the employer?
Yeah, thank you very much, Claire. That is a question I think that all the panelists, not least Jeff, can give an opinion on. But panelists, any takers for this, please? Jeff, what's
it? To offer the first view on that one. I mean, I would confine my answer to South African law, and I would stand corrected on this, but my answer to that in South Africa was that regardless of one's immigration status, the employment laws would still apply. And if one is found to not have the appropriate immigration status to maintain employment, in my view, it would ordinarily be a dismissal based on incapacity and legal incapacity, where the employee is unable to occupy the role in which they've been employed. That would, in my view, specifically be the employment law answer, subject to what my panelists would like to supplement.
Thank you, Alex. Professor Chido, this is a constitutional issue as well. Do you have any take on it, please?
You're clearly making me pay for my dinner, hey? So,
there is no dinner for your sins.
The employer, it's an unlawful. The contract would be unlawful if it was in breach of the statute. So I think incapacity would be probably that would be the basis for the termination. But but whether you're documented or undocumented, you have to be treated the same as South African workers in terms of wages, working conditions, and your, but I think, the constitutional issue is, would the Immigration Act be unconstitutional? I doubt it. I think every country has an Immigration Act of one kind or another. Yeah. So I think, was Jeff or Alex's answer that it's an unlawful relationship? Yeah.
Thank you, Adam. Jeff, surely you must have abundant similar cases in the US.
No, but I mean, I think just to maybe take it from a more of a human rights perspective, of course, countries have the ability to determine who enters their territory, right? But I think there is also a recognition that if somebody enters into an employment relationship, regardless of their status, I mean, and in many cases, you're going to find that employers may knowingly hire somebody that is not documented in order to take advantage of the precarious nature of their position within the country, right? Than to exploit that worker. Uh, so, there have been, approaches, and I think this is also with regard to the ILO as well, I mean, there should be, as a principle of labor inspection, there should be a firewall between labor inspection and immigration enforcement. So if there is a labor dispute, regardless of the person's immigration status, that must be treated as a labor law matter, and labor remedies should be available to those workers without the immigration question entering into it. Of course, immigration authorities can enforce their laws as well, but it shouldn't be using labor enforcement as a means to enforce immigration laws, especially given, as I said at the beginning, employers often knowingly engage workers that are undocumented for the purpose of being able to hire them unlawfully. I mean, not all employers, of course, but it happens, right? So I think this idea of separating labor and immigration enforcement is a principle that's been articulated by the ILO in the past.
Thank you, Jeff. Claire, what's the next question, please?
Professor Stefan Panek, could we expect Section 39(1) of the Constitution regarding interpretation and this ICJ decision potentially play an important role going forward in South Africa?
That's definitely Professor Chido's question. He's a constitutional lawyer. He's got many sins, this man. For those who might not know, he was a constitutional lawyer before being a labor lawyer, I think, almost. Please, go ahead.
Well, I wanted to do two things. I think Jeff has just spoken about the very strict separation between inspection roles, and certainly under the inspection conventions. And I remember being on the convention, on the committee, that there was very strict separation between migration and labor issues. And it seems if there's a labor dispute, then the labor law would apply. The problem comes actually with the question of whether or not the Immigration Act has the effect of making the contract of employment unlawful, and therefore not valid. And I'm just sort of rethinking about it. I mean, it would be a criminal offense for the employer, and the employee would be deported. But I think it really does depend on a very, very close look from a human rights perspective of what the impact of the Immigration Act is on dismissal. So if I'm reversing slightly, I'm doing that on reconsideration after listening to Jeff. As far as Section 39(1) for the audience, Section 39(1) obliges the courts to take into account international law, and there's no question that a decision of the ICJ would constitute international law, and on top of the fact that South Africa has ratified that convention. So I don't see that there's going to be any impact, because the LRA was drafted together with the experts inside the ILO, and really the right to strike provisions, including the right to lockout, well, let's just say the right to strike provisions, follow very closely the jurisprudence of the Committee of Experts. And so I wouldn't see really any change. Obviously, things will change once we get moving into areas of platform work, supply chains, and all of that. Our current law on strikes doesn't and picketing doesn't address those issues, and those are the kinds of issues that would require legislative change. And I think those are the kinds of issues that the CARCR is going to have to deal with. And once it deals with it, then of course courts are going to interpret our legislation in accordance with the jurisprudence developed by the Committee of Freedom of Association or the Committee of Experts.
Yeah. Thank you, Prof. Alex and Jeffrey, any thoughts on this as practitioners?
Well, at least, I mean, I fully agree. I at least in a country like South Africa, where we have a right to strike, has been quite firmly entrenched here since we've had, at least first we have the Constitution that gives a right to strike, and then we have the Labour Relations Act, which follows sort of what the existing law is on it. So I think that probably the big, and I agree fully, that probably the big question is not going to be about, in terms of Section 39(1), on sort of the traditional right to strike. A lot of those issues seem to have come before the courts, at least here in South Africa, and have been fairly settled. The issue is going to be moving into different types of work and how to give effect to the right to strike and to what extent going forward. I also agree. I'm not sure if that's something that courts are always, as much as, you know, and that's probably a bit of more of a philosophical debate, but whether courts are always best able to do the sort of comprehensive change that the law would need in order to give effect to rights to strike for things like platform workers, or whether that's something that's best done by sort of full-on legislative change. But I think that, yes, as a general thing, will it change too much from that? No. But I think on the platform workers and those other types of forms, when they try to exercise collective bargaining rights, and because they don't fall easily within the existing LRA, they don't necessarily always fall within the definition of an employee, that's where it could play probably quite an important role.
Thank you, Jeffrey. It's interesting, Professor. Yes. No, I'm saying it's interesting. Before you move on, before you come in, Claire, I was going to mention that it's interesting that Professor Chidom mentioned, implied about the compliance of the Labour Relations Act. It's a mixed blessings for South Africa, because the Labour Relations Act is probably the most compliant legislation with ILO standards. And but that brings with it, if you judge from the cases against South Africa, there have been about 7 cases. It implies it's a mixed, luckily those cases, I think in at least one, the Constitutional Court were in, and the South African government's claims were upheld. But it's a mixed blessings. It holds you to a very high standard. Whether you want to temper with that in view of the new developments, it's another matter. Just wanted to, to share that South African labor law in general, the Labour Relations Act in particular, is probably the most compliant with ILO standards as we speak. Next question, please.
We don't actually have any more questions. We did have one, but it was answered previously.
Yes.
Advocate Duco confirms that in Lesotho, no one can work while undocumented. He just commented on that. And Letsy's question was actually answered. So we don't have any more questions. So
It's two
not sure.
added.
Oh, two have just popped in. I'm sorry. Apologies. Thank you,
Okay,
Connor.
no, you go ahead, please. Can you share
I think
them, please?
we've got 9 minutes, so we can answer quickly.
Yeah, sure.
Sticks is asking, should the ILO not have a common consensus on whether or not the ICJ advisory opinion is binding on it? What would be the next available remedy to resolve this?
Either Jeff or,
Yeah, sure, I can
Chido.
take that up. I mean,
Can you? Yeah.
yeah, I mean, I agree with Professor Cheadle. I mean, I think my personal view, but also the institutional view, the ILO has been up to this point that Article 37 of the Constitution does refer to the advisory opinions of the ICJ as constituting a decision, um, and has taken the position that, as such, and the fact that there's no other body to appeal to, that those advisory opinions do constitute decisions which are binding on the ILO as an institution. But we will have a tripartite discussion in the governing body in November about the content and impact of the advisory opinion on the ILO. So that will be the next opportunity when we will have to discuss exactly how to treat the advisory opinion.
Thank you. Thank you, Jeff. Prof. Chido, any further thoughts on this, please?
Nothing from Helton. Should I ask the
Uh,
next question?
Yeah, yes, you go ahead, please.
Thank you, Jim. If right to strike is recognized as customary international law, as Judge Cleveland suggests, is an implication of the ICJ decision, how will that affect issues like those raised by Jeff, solidarity actions, protest actions, competition law, reenactment of collective self-employed action? Jeff, you're welcome to read the question on the question and answer. If it didn't make sense to you, apologies.
Yeah.
Well, since Jim has actually written a law review article on the right to strike as a principle of customary international law, maybe he can answer his own question. I mean, I think you can also even read the majority opinion. They don't say it in so many words, but they come close to saying what Judge Cleveland says explicitly. It is a good question. What further having that principle articulated as a customary international law would mean, as opposed to one that is rooted in the ILO convention. I mean, obviously, it would be to the extent that there are countries that have not ratified the convention or the two covenants that are somehow the few countries that are outside that scope. I mean, that would be applicable to the extent that that state respected customary international law. I'm not sure that it informs the content specifically of any of these emerging questions, other than the fact that if you have a customary international law norm, it's obviously elevating a principle to a higher standard. It's not peremptory, but I don't know. I have to give that more thought, and I would be interested in hearing your views on this, Jim.
Okay. Prof. Chido?
Well, I relied on Jim's article. In fact, we attached it to the South African government's submission, and we argued for it. Again, I think it would be international customary law, like common law, gets developed, and as Jeff says, applicable to the few countries that haven't got a right to strike or haven't signed on to either of the two covenants or Convention 87. And again, in developing customary law, you would look authoritatively at what the two ILO committees have decided over time. But I would see it's only really being employed in a complete prohibition on strikes. If one looks carefully at both Jim Rudney's article and the judgment, the majority judgment, the assertion is very often made not around scope, but around the existence of the right to strike. So it seems to me that to the extent that it would ever be employed, it would be employed initially on a complete prohibition of striking at all. But yes.
Thank you for that. Claire, do we have any more questions? Yeah, yes, do we?
I think we should close now, Prof. So Keshni will pick it up, and Lebogang, we will answer your question directly.
Yeah.
Thank you.
Okay, before we do that, we've got 3 minutes left. Half a minute for each panelist to final thoughts, please. Professor Chido, go ahead, please.
Okay. Well, what can I say? Thank you very much for the opportunity to address you, and I really enjoyed listening to my colleagues here on the panel and the questions. There is a hell of a lot to talk about, but I've really enjoyed it. Thank you.
Jeff?
Same as Professor Cheadle, thank you very much to the African Labour Law Society for putting this together. This is, as a labour law matter, one of the most consequential decisions that come by in quite some time, and I think will be, there's a lot to debate about the decision and how it's going to play out in member states and within the ILO itself. So looking forward to continuing those discussions, and again, thanks to all the co-panelists. I learned a lot from all of you. Thank you.
Thank you, Jeff. Alex and Jeffrey, please.
I think it's just briefly to reiterate our thanks to the Society and our colleagues for what's really been a great afternoon, and looking forward both to seeing how this particular issue develops and about how, let's say, a renewed energy, considering the great weight comments, for practitioners to pay more attention to what the ILO supervisory bodies are saying.
Thank you, Alex. Jeffrey?
Thank you. I agree. Thank you for the opportunity. And I agree with what Alex has said. I think that what's really good about this case is that it has sort of, I think, sparked up more of an interest, at least for us as practitioners, but maybe also just for people generally, to sort of sit up and take a closer look and a greater interest into how the ILO works, what it does, and sort of the effect or how to use these interpretations going forward. So I think that it is a good development, and it's going to be interesting to see where it goes in the years to come.
Thank you very much, colleagues and friends. It remains for me to thank the Society again and congratulate you, Society, because at this peak, I think we had over 70 participants. This is an excellent kind of enlightenment event, and I wish you the same in the future. And as for me, it's been a privilege, as always, to facilitate this and cheer you on. Thank you very much, colleagues and friends. and the debate will continue, I'm sure. But at least we've got it started here in the society. The society. Thank you very much, Claire, Connor, and the team, Vice President Keshini, Naika. That sounds, you, and of course the president and the executive. Thank you very much. Goodbye.
Colleagues, as we draw the webinar to a close, we would like to extend our sincere thanks to our panelists and our moderator, of course, for sharing their expertise and insights with us. I think what the discussion has highlighted, besides the significance of the opinion and its potential implications, is that the conversation about its practical application and future developments will certainly continue. So on behalf of the African Labour Law Society, thank you to all our participants for joining us and also for your engagement. And we do look forward to welcoming you to future African Labour Law Society events. Have a good afternoon, everyone.